Hi, I'm Jack Gately from GatelyAcademy, and in this lesson we're going to talk about the Massachusetts Board of Registration. So the Massachusetts Board of Registration is part of the state government, and it is the agency in the state government which issues you your real estate license. So they issue basically three types of licenses: the salesperson's license, the broker license, and also the agency license. They also approve real estate schools and real estate instructors. So they do all of that, plus they handle disciplines for anybody that is licensed by the Commonwealth of Massachusetts Board of Registration. They handle discipline issues before the Board of Registration. Now, the Board of Registration, Massachusetts Board of Registration, we call it, of Brokers and Real Estate Salespersons to be the official title, was established in 1960, so it's very well established agency. It has five total members. They're all appointed by the governor, including the chairperson, also appointed by the governor. Three of these five members of the board must be brokers, and each one of those brokers must have 7 years of experience in order to be even eligible to serve on the board. The other two are members of the general public, and very often at least one of those members of the general public is usually someone representing the legal community. Not exclusively, but I think that's somewhat of a kind of unspoken rule, not officially. They must meet at least 4 times a year, and every meeting has a minimum requirement there that out of the 5, 3 must be present in order to conduct business. We call that a quorum. So this is your Board of Registration of Brokers and Real Estate Salespersons in a nutshell. Let's talk a little bit more about their powers and why you don't want to hear from them. Because, of course, other than issuing your license and also renewing your license, your average licensee will not hear from the Board of Registration, as long as you're doing what you should be doing and you're not getting in trouble. If you're not getting in trouble, you're probably not going to hear from them until it's time to renew. But if you do get in trouble, then that's another story altogether. Let's talk about the approximate 11 things that you could do, maybe 12. It's probably an infinite list, really, but we'll kind of keep it to 10 or 12 things. We'll talk about the 10 or 12 things that you could do to get yourself in trouble with the Massachusetts Board of Registration. So in no particular order, let's take false representation first. I believe that false representation is actually a common thing that the board deals with, especially for folks that renew their license without actually doing their continuing education. When you renew your license, there's a form, and you have to check a box saying that you did your continuing education, and then you sign that form. The problem is some people check that box and they haven't done the continuing education. The current process is you do not send in any documentation. You just check the box. But if the board checks and you don't have the documentation, that means you renewed under false representation, and that is going to get you disciplined by the board. Highly likely a license violation. You might not lose your license or get it revoked, but you might be suspended for a short period of time. It's a serious violation. If you're willing to lie about 12 hours of continuing education, what are you also willing to lie about? So as far as I'm concerned, very serious violation. You're willing to lie to the state government. Well, who else are you lying to? All right, next, dual agency. Acting as a dual agent representing the buyer and the seller at the same time without their consent. Now, this is totally legal if you get both people's consent, the buyer and the seller. Totally legal. But if you don't, then you're in big trouble. So most people get the seller's agreement in the listing agreement, and then there usually is a separate form for the buyer to sign. So very easy to do, but if you don't do it, you can't unring the bell. If a transaction occurs and you're representing the buyer and seller, without their consent. You can't go back in time and kind of get a redo or a go-over or whatever you want to call it. No, yeah, it's like impossible. So that transaction could have happened differently. Maybe the terms would have been different in the transaction if both parties knew that you were representing their opposite number, so to speak. So very serious violation. You need to get both parties to consent. And if you don't, that's definitely going to find you. If they complain, which they should, that you definitely find yourself before the Board of Registration in that regard. Undisclosed principal. Undisclosed principal. This is a really easy one. If you are selling your own property, then you need to disclose it. Just write in the listing in the MLS, the multiple listing service, agent is seller. You probably want to carry that language over and maybe actually mention yourself by name in the purchase and sale agreement where it says, your name, the agent is also the seller of record or something like that. Really simple one sentence thing, not hard to do. Nobody really cares. And it's only the cover up that gets you in trouble as always, right? So if you're acting as an undisclosed principal, that is also a big no-no. Failure to account for funds. Let's put a star next to that one here. Maybe 2 stars, actually. This is probably the topic that attracts the board's attention like no other. The sanctity of the funds in escrow are critical for our whole system to work as it is currently organized. So when someone writes in a deposit, the fact that it's actually going to be held in trust in a safe escrow account is critical for the functioning of our industry as a whole. And if that confidence breaks down, then we as an industry we're in deep trouble. So the board takes these violations extremely seriously, as they should. And of course, we're talking about handling escrow money that is client money, usually deposits that are on escrow pending the closing of transaction. It's client money. It's not the broker's money. It's not the agency's money. No, none of that. It belongs to the client. And really, as a broker of record at my agency, or if there's a broker record at a sole proprietorship, or I should just say sole proprietor, if there's a sole proprietor, there's no reason why any of that should be in doubt at all. And if there is a doubt, then the board was going to take that up with extreme how do I want to say this? Scrutiny. Yes, scrutiny would be the good word. It is a very, very serious violation. Let's go on to the next ones. Okay, number 5 on our list, sharing a fee with a non-licensee. And so, if you start to think, oh, hey, I can start giving a little bit of my commission, which is the slang for the word fee. Technically, we want to use the word fee. You want to use the word fee on the exam. The word commission is more like slang. How about I give my commission, I'll split it with the landscaper that recommended me the house, the people to the house that I sold, or something like that. Or I'll split it with the house painter that gave me the lead. No, you can't do that. It's I get the idea where you might want to, come up with additional lead sources, and you'll say, hey, I'll split. If I sell that house, you find me some houses to sell. I'll duke you a certain percentage of my commission. That, when it dawns on you in your head, you're like, that's a really good business move. Yeah, no, it's not. Then you're going to find yourself before the Board of Registration for that one. So you cannot share your fee with a non-licensee. 6, receiving an undisclosed fee. Also, really very, very serious. If you're going to be getting a fee of any shape or form, it must be disclosed. I'd like to think that we do that a much better job in our industry nowadays of disclosing fees. In almost every standard purchase and sale agreement, the agencies that are receiving the fees are listed, usually the exact percentage of the fee is also listed, and even some attorneys add on addendums to purchase and sales agreements, which in sometimes actually list the agents by name. So I'd like to think number 6 is not nearly as big of a problem as it may have been decades ago. 7, induce party to break a contract for your own benefit. Think of the exam question be like this. Sally made an offer on a house which got accepted. She then finds some other house which she loves even more, and you're the agent for that house. And you say, hey, Sally, I know if you back out of that other transaction, you're going to lose your deposit of $2,000. How about I'll give you that $2,000 out of my commission if you go buy my house. No. You can't do that. You're encouraging Sally to break her deal so that Sally can buy your house, and then you're giving her $2,000. You're giving her deposit back. You're making her whole on the deposit she would have lost. That is an inducement, and yeah, no, you cannot do that. That is a no-no of the highest order. You must provide copies of anything your client signs. This is number 8. You must provide a copy of that. It's really simple, right? If they sign something, give them a copy of it. Hey, 2 more. A net listing. A net listing is when you sell the property and the seller agrees that you're going to get everything over a certain price. So if, say, the seller says, hey, I just want to get $150,000 for my property. Hey, Jack, if you sell it for any number over that, that'll be your commission. So basically, you're selling it, and your commission is the overage, the number over 150. So if you sell it for 170, you make 20 grand. If you sell it for 250, you make $100,000. And that puts you at conflict with your own client. This is called a net listing. It's illegal in Massachusetts. You cannot get the overage on a piece of property. You can only work for a percentage. Percentage is fine because in a percentage, the interest of the client and the interest of the agent are aligned because they both benefit from a higher price. But in a net listing, the agent actually benefits if they can talk the seller down. Oh, you wanted 150. I think I can get you 120. And then they ended up selling it for 210, right? So the lower you can get your client to say that they'll accept, the more money you make. And now you're working at an opposite interest of your own client. Net listing is a no. And then lastly, on these 10, again, not an exhaustive list, but proved violations of the Massachusetts Fair Housing Law, as proved by the Massachusetts Commission Against Discrimination, often known as MCAD. So your first violation there is going to be an immediate 60-day suspension, and your second violation within 2 years will be an immediate 90-day violation, immediate 90-day for a second offense within 2 years. Might be good to know, though. Those sounds like really good test questions right there. Immediate violation of 60 days and then a follow-up of 90 days within 2 years. Those do sound like good test questions. And if they do hold a hearing about your conduct, there's some important deadlines that you should be aware of. Careful now, of course, you should remember the board can hold a hearing at their own initiative or as a result of a complaint as well. The board can subpoena witnesses and subpoena records. You are allowed to have an attorney if you want as a licensee, but you're not entitled to an attorney as a licensee. So really quickly, the procedures are this, the board notifications. If they're going to have a hearing about your conduct, the Board of Registration, they must issue you a 10-day written notice. This is part of the overall due process. If you don't like the outcome of the board hearing, you must appeal within 20 days. If part of the discipline issued by the board includes a surrendering of your license, you must complete the surrender within 7 days of the board finding. So just once again, remember now, they can subpoena your records and witnesses. You're allowed to have an attorney, but it's not a right. You're not to have an attorney. So very, very important. And they can conduct a hearing based upon a complaint or at their own initiative. Lastly, just remind ourselves that, of course, the board can ask to examine your records. And most especially, this would be relative to accounting of funds that we talked about earlier, the escrow account. And literally, like at any time, the Board of Registration could ask you for your escrow account records, especially if you're a broker of record at an agency or a broker at a sole proprietorship. And as we hinted earlier, they could ask you for your continuing education documents or really pretty much anything relative to your license.